Okay, so we're just about to start. Thanks to those of you who have joined already. We're just waiting for a few more people to join. There's a sudden spike in numbers as we hit the kickoff time. So look, I think we will start with brief introductions. My name is Nick O'Connell. I am the partner responsible for Altamimi & Company's technology, media and telecommunications practice. I am sitting in Dubai as we speak, although I am usually based in Riyadh in Saudi Arabia. Our technology, media, telecommunications practice does a lot of work in the broader data and cyber space, and data protection is a big aspect of that. So we do a lot of data protection work. Personally, I'm also a certified information privacy professional, CIPPE. So the data protection side of things is something that I handle a lot. And in that context, I'm working with our colleagues in Egypt, including Ayman Noor, who's here today, on data protection related matters. And we're also joined by Norris Ismail from Ankura Consultancy. So I'll let both Norris and Ayman introduce themselves. Norris, would you like to go first?
Sure. Thanks, Nick. A very good morning from London and afternoon to everyone who's listening to the webinar. I'm Norris Ismail, Managing Director of Ankura Consulting Practice. I'm actually leading the UK, Europe, and Asia on the data privacy side within the technology privacy risk cyber advisory in the data technology practice based in London. So for those who have not heard the brand Ankura, we are actually a global professional services firm, globally headquartered in Washington, DC. We have offices around almost 25 countries around the world and around 1,500 people. And most of the activities are very much within the advisory side.
Well, this is Ayman Noor. I'm a partner with Altamimi and head of Egypt office. I'm working with the team all around the region in Altamimi regarding person data protection and TMT in general. And I'm happy to be here today with you and discussing the new data protection law in Egypt, freshly introduced.
Great. So in terms of the format of today's session, I think we're scheduled for perhaps about an hour, but in terms of what we have in mind, we're basically going to have a conversation regarding some of the key issues that we have identified in the new law. And after that, Norris will tell us a little bit about the operationalization side of things, which he's experienced with from other jurisdictions. So that's the general sort of outline. Joe, if you could show us the table of contents, that would be great. I'll also mention that we're going to have an opportunity for questions later on. So if you submit questions through the platform, we'll try and pick those up depending, either during the course of the discussion or at the end, depending on how we're going for time. So that's the plan. Let's start. Ayman, so first of all, I thought it would be quite useful to talk a little bit about the application of the law and the timetable. Perhaps first the timetable, because a lot of people have asked us, well, exactly by when do we need to get compliance? So can you tell us a little bit about that?
Yes, Nick. The law was out on 15th of July 2020, and it will come into effect on the 14th of October this year. However, there is a grace period for compliance that starts 1 year from the issuance of the executive regulations of the law. And this is due on or before 14th of April. So we really expect the executive regulations to be out before 14th of April. I hope it doesn't come out after it, because there were some precedents with the executive regulations of other laws that came out after the deadline or the due date prescribed by law, and this, of course, causes issues with respect to its enforceability. So I hope with the current regime, the executive regulations will be out on or before 14th of April.
Great. And so the punchline is that data controllers and data processors that will be subject to the law, they do have time to get their houses in order, potentially a year from when the executive regulations issue. Yep.
Yes.
Okay.
Correct.
Now, in terms of the application of the law, there were a couple of points that that struck me as being of interest. The first thing is it has a lot of those typical carve-outs in terms of things like processing of personal data for personal or household type purposes, processing of personal data for journalistic or media-related purposes, processing of personal data for law enforcement, national security type purposes. Those sort of exceptions apply. But interestingly, there was also a specific carve-out relating to entities regulated by the central bank. Can you tell us anything about that? And I should say
yes.
it's a partial carve-out.
Yeah, it's a partial carve-out because the exchange offices and transfer offices are not carved out. However, the entities and the law provides for entities under the jurisdiction or competence of the Central Bank of Egypt. It didn't say banks, so we're expecting more than banks. And in this respect, Nick, the data protection law is alluding that the Central Bank of Egypt will issue regulations or decisions or decrees regarding the data privacy and how banks should comply. We have seen the draft banking law, and really the privacy, the accounts privacy and confidentiality clauses are very generic. They are not covering all the aspects that we have seen in this data protection law. So
right.
We're expecting that the Central Bank of Egypt will issue more directives on this subject.
Right. So essentially that carve out in respect of entities regulated by the central bank, it basically says provided those entities are subject to data protection rules established by the central bank. But the central bank at this stage in their new banking law, they have alluded to banking confidentiality type provisions, but they haven't mentioned anything that we would recognize as data protection provisions as such. So whether that means that they will separately issue data protection, financial services sector data protection regulations or not, we have yet to see. The other point is there is this exception relating to money transfer companies as well. So we don't need to talk about that, but it's important to note that that the money transfer companies, although they are regulated by the central bank, they are also subject to this new data protection law. So it's an exception to the exception.
Correct.
Okay.
I would like to mention. I would like to mention as well in the beginning of this webinar that this law is meant to, with respect to protection of personal data electronically processed. So there are two elements very important to mention here. First of all, it's the personal data, not like juristic person. It has to be an individual, so it's a personal data in this respect, and only electronically processed. So, I mean, if you print out the data and you have physical documents, this law does not apply technically. This is something that I don't know whether the GDPR and other data protection laws in other jurisdictions apply the same concept.
No, well, I think generally, I mean, I was surprised to see the definition of personal data where it does talk about electronic the definition of processing, where it talks about electronic or technical processing. So other jurisdictions often contemplate data that's being, collated or collected for use in orderly files. I mean, the wording eludes me at the moment, but it's not typically limited just to electronic data processing, although what you're saying is that in the Egyptian law, actually it is limited to electronic processing. So that's interesting. Yeah. Just in terms of definitions, I don't think we need to sort of go through each definition, but besides the definition of processing that you've flagged just now, the definition of sensitive personal data was somewhat interesting to me. It's broadly what you would expect. There's a couple of things missing, like criminal records, etc. Listed. But
criminal records could be covered in the carved out provision in Article 3, Nick, with respect to the juristic or judicial investigations and reports, and so maybe this is where it's covered, that this is something that is confidential under another law.
Sure. Now, on sensitive personal data, interestingly, there is a part of the definition says that in all cases, personal data relating to children shall be treated as sensitive personal data. So that's a little bit atypical, I would say. Okay, look, let's move on. The next topic that I was hoping to briefly talk about is the principles in the law, and also the idea of lawful processing. And I don't think we need to go into too much detail on this, except to say that this idea of principles. So in the GDPR, for example, they talk about lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality or security, and accountability. The Egyptian law, it doesn't specifically mention those 7 items in that way, but it does basically cover them off. It mentions 4 particular items which we can, broadly fall into that, the purpose limitation aspect, the legitimacy aspect, the data minimization, and the security aspect. And so it gets us there. And then in other parts of the law, the remaining aspects are covered off. So I would say, broadly speaking, the GDPR principles are captured in the law, but just not quite in the same way. In terms of, I just wanted to also talk about the legitimate processing or lawful. They use legitimate and legal in the law in the same sort of section. But again, it's very similar to what one would find in the GDPR. And someone's just trying to call me. I hope they're not trying to call me to tell me that this isn't broadcasting properly, but we'll keep going. In terms of legitimacy and lawful, the Egyptian law specifies basically what can be understood as the consent aspect that we find in the GDPR, the contract aspect, the compliance with law aspect, and the legitimate interest aspect. So each of those conditions, if met, will mean that the processing is broadly lawful. Now, there might be other lawful reasons not mentioned in the law, but essentially, if you have the consent of the data subject, that's one. If it's required for pre-contractual or contractual measures associated with the data subject, that's another. If it's required under a legal obligation or in the context of judicial proceedings or that type of thing, then that's another one. And then there is, of course, the general one, which allows for the controller to be processing if they've got legitimate reasons to do so, and if those reasons aren't outweighed by the impact on the data subject. So again, I would say, while it's not captured in exactly the same way as the GDPR, broadly, a lot of those points are covered. If we can, Joe, if you can perhaps just put the content list up again so that people can sort of see where we're going. The next item that we're looking at is consent. So consent in the Egyptian law, as I've mentioned, it is one of the grounds upon which personal data processing could be legitimate or lawful. It's also interesting to note that the law introduces the ability to withdraw consent, and that's something that, again, it's in the GDPR as well. So, I think Egypt is trying to sort of emulate the position in, what is becoming the international standard sort of position in both permitting consent as a basis, but also permitting the data subject to withdraw consent. So, Ayman, can you tell us a wee bit about consent in the context of Egyptian law?
Well, yes, consent here is mentioned, and it doesn't need to be defined, because the general civil law, it has in the chapter on agreement, it has a very detailed definition, and it explains what consent is. But in view of the data protection law, the mere pressing or action of pressing on a agreed or whatever on the screen or on your laptop, it is a consent under the definition of the law. So the data protection law did not need to go to cover what are the how do you define consent, or how do you interpret consent. Okay,
so consent is basically defined elsewhere in Egyptian law in the civil code, did you say?
The civil code, yes.
Yeah. Okay. Norris, just to bring you in, that from an operational perspective, the ability to withdraw consent, can you briefly talk about how you have dealt with that in other countries, or whether that is in fact an issue in other countries?
Yeah, thanks, Nick. I think it's a very important fundamental question. If I could recall 3 years ago when the GDPR was actually enforced, and there's lots of debate about how to operationalize consent. And we're seeing different approaches at the time where some mature organizations have actually approached consent quite strictly, partly because they actually really deal with B2C data processing activities every single second. And some organizations which actually rely on legitimate interests, for example, HR data, they actually have to formalize this by way of that particular reason, rather than asking repeated consent most of the time. And then some organizations which are startup, like SMEs and local companies which do not have global outreach, they just use consent as per one-off basis. That was during the first 2.5 years. And then during the third year, in fact, after 2 years of GDPR, we are seeing where many mature organizations learn from that process. So what I meant by learn from the process is that they use the technology to actually operationalize the consent by way of the opt-in, opt-out, and as well as there's also a cookie element as well, which is also part of the additional obligation in the GDPR. And then when we look into a much more non-GDPR jurisdiction perspective, comparatively, if you look into jurisdictions like in Southeast Asia or even in China, interestingly, some of the jurisdictions in Asia are okay with implied consent. What does it mean is that it is okay for the organizations or the data controller to really process the personal data on the basis of implied consent. However, having said that, we have seen that the GDPR baseline has actually triggered a much more risk-based approach to global organizations that are very much B2C focused. So in short, to answer your question, there are two elements that we have been observing so far. The first is operationalizing consent more from the the tech perspective, meaning having a tool to actually be deployed or to be plugged in a particular website, or even in an app environment, or even in a very, very agile environment, just to ensure that the consent is actually being really called out in that case. The second point, which is equally important, is to always update whatever changes of terms in relation to the consent aspect, because business model change, business strategy change, business expansion might actually differ in the next 3 to 5 years, or even within a 1 year.
Yeah, and I think one of the things that when we've been looking at consent as a basis for processing more broadly, not in Egypt, but more broadly, and that is that, in the past it was often seen as perhaps an easy way to legitimize the processing of personal data, but it's actually deceptively, like, it's not an easy way, and it's not the best, necessarily the best approach, because there are flow down effects if you do elect to rely on consent, and the fact that consent can be withdrawn is just the tip of the iceberg. So yeah, okay, look, let's move on from consent. I wanted to briefly talk about data subject rights. Now, once again, I think the data subject rights do seem broadly consistent with what we see in GDPR. So there's things like there's a right to be aware of what personal data is being processed by whom and for what purpose, etc., and to have the ability to access that information. There is, as we've mentioned, the right to withdraw consent, the right to correction and modification, erasure, updating, etc. The right to object to processing. Now, interestingly, there's also a right to be aware of any data breach related to the data subject's personal data. So we'll talk about that again in a moment, but I thought that one, it's interesting because it's expressed as a right. Significantly, at the moment, the law contemplates data controllers being allowed to charge data subjects for exercising those rights, with the exception of that right to be notified in the event of a breach. And it also contemplates quite a high fee. So I know in the UK, I think it was previously £10 if you wanted to submit a data subject access request. But they've done away with that as far as I understand it, whereas the Egyptian law contemplates a fee that a data controller could charge of up to $1,250, which, I mean, that's big money where I come from. And I think in Egypt, it's particularly big money. So now that is an upper level on what the law contemplates data controllers being able to charge, but it will be specified in the executive regulations. So I just thought that was a little bit curious, and we'll wait and see. It's slightly against the trend, I think you could say. Okay, just moving on from that topic, and Joe, again, if you want to bring that slide up briefly. I want to talk about accountability, and under that, I thought we can talk about the data protection officer role, and also the record keeping obligations. So, Iman, are you in a position to tell us a bit about the DPO role?
Well, this is a big role because the penalties on any negligence or non-compliance by the DPO is really big. It goes to imprisonment and big fines. So, well, the DPO should be conducting periodic assessment and examination of personal data protection. He has to act as a direct point of contact with the authority and implements its decision. He has to enable the data subject to exercise his rights stipulated in the law, respond to requests submitted by the data subject or any other concerned person, and respond also to the authority regarding grievances submitted by either of them. Follow up the registration and updating of the controller's personal data registration, and removing violations of personal data within his entity, and organizing the necessary training programs for his entity's employees. So it is a big role because of the how the law perceives non-compliance and negligence in this scope.
I think one thing that's particularly interesting to me is the fact that the way it's expressed in the law, this is not an optional role. So just to give you a bit of context, I've been looking at the position under the DIFC data protection law. So DIFC here in Dubai has a new data protection law as of 1st of July, I think, and it will come into effect from 1st of October. Now, in terms of the data protection officer requirement, if the organization reaches a certain sort of threshold, then there is a statutory requirement to appoint an independent or a DPO who can act independently. Now, that threshold, I don't have the provision sort of on hand, but essentially it is if you're processing a high volume of data and that processing is high risk processing activity, which is defined in the law. I mean, there are a couple of other criteria, but the point is not everybody under the DIFC law needs to appoint a data protection officer. Whereas under the Egyptian law, the way it's worded, everybody needs it.
In Egypt, it's mandatory. There is no threshold to appoint a DPO.
So it's not just big companies or companies with a certain number of employees. Any company needs.
Yes, exactly. And it's coming in the law. It's not even in the executive regulations whereby you can put certain requirements or requisites. It's in the law, and there is no threshold.
Right. So we can't expect that the regulations will be able to somehow dampen down this expectation.
If the regulations contradict with the law, they are null and void. So they cannot contradict with the law.
Okay.
So I don't know whether there will be a way to get out of this requirement, but under the law, it is a requirement. Absolutely.
Like practically, it's going to be interesting because on the one hand, massive employment opportunities for data protection
creating
officers.
Jobs.
On the other hand, significant criminal penalties for data protection officers in Egypt. So, you know, good luck. Good luck with that.
Yes, it's a difficult role to assume for anyone, any person.
Yeah. Okay. Oh, and then the other point I think with the DPO is that they need to register with the authority, don't they? That's also one of the requirements. So, all right. Well, look, I think that DPO aspect is particularly interesting, and it's in practice, I think it's going to be a difficult one for. I mean, you know, if you're a big international organization used to having a data protection officer, no issue. But if you're a small business processing modest amounts of personal data, but that requirement still applies to you, it will be, you know, a little bit impractical, I think.
Yeah, I don't envisage that there will be like service companies where they can serve as DPOs, because as you see, you have to appoint an individual. So it is not, you cannot solicit the services of or outsource the services of a DPO under my understanding from the requirements in the law.
Interesting. Norris, if you're looking to move from cold and dreary London to Cairo, there might be a role there for you, perhaps.
With a big risk.
Yeah. So look, that's great. Let's move on to the next topic. I'm just conscious of the time, and that is security and breach notification. So once again, I think for the general security considerations, it's similar language to what we would expect to see in, or what we do see in GDPR. So it talks about, it talks about keeping personal data safe and secure, but it also talks about implementing technical and organizational measures, etc. So it's very much the language that we would expect to see. One of the things that I did notice was the executive regulations, like Article 3 of the law contemplates the executive regulations perhaps providing further detail on what the relevant security measures might be. So although it's not explicit in the law, it could be that the regs come out and provide more specific detail in terms of what they are expecting on the security side of things. On the breach notification side of things, again, Norris, is that something that that you're able to talk to?
Yeah, sure. For this audience who have actually experienced or perhaps encountered unreported data breaches in the GDPR world or GDPR universe, you might have actually experienced having dealt with the respective local data protection authorities. So that's one aspect of it. Another aspect of it is the DPO or the Global Chief Privacy Officer has to work very, very closely with the CIO and CISO just to ensure that both team members are actually working holistically in relation to notifying, the breach. Our experience, having dealt with a variety of breaches cross-sector, I would categorize this into three categories. The first category is global mature organization, very centralized, and they do have the resource and they have the budget to really do the forensic investigation, sought the legal counsel advice, from the respective lawyers in the jurisdiction, and as well as having a structured DPO kind of a structure, they're able to respond it within the required 72 hours because of the fact that they do have the resource and the team to deal with breaches. Most of these organizations are predominantly within the financial services sector, and I would say that the energy sector and as well as the telecommunication sector, because they have been investing a lot in advance, even prior to the GDPR enforcement. And we have the second category of organization where the organization doesn't have a full-time DPO, even though it's quite debatable to have full-time, DPO in the context of their business processing activities, where they outsource the DPO function or even the CISO function to lawyers or consultants or even independent contractors to deal with data breaches. And the fact that they also have actually signed cyber insurance as part of their organizational structure and environment. And within the cyber insurance, of course, they can really use certain terms and conditions of the insurance terms to claim in the event there is actually a breach. Typically, of course, when we look into the first category of organization, most of the financial services, TMT sector, they do have cyber insurance. But the second category of organization is that they do not have the resource to help them to respond to these kind of breaches. So in the context of the UK, the ICO has been very, very pragmatic in relation to some of the, asking investigatory questions to organizations. But for those global CPO, DPO on the call or on this webinar who have dealt with a much more stricter regulators like Germany or even CNIL, French, and Data Protection Authority in the Netherlands, or even in Ireland, Data Protection Commission in Ireland, it depends on the officer, the lead officer, investigation officer that are actually dealing with the particular case or particular breach. So it's very, very important to be very tactical and very, holistic, and it's very important to have a storyboard to really, really ensure that all stakeholders are on the same page, because do not actually disclose too much information. Is very important just to be very precise and then conduct the necessary audit and investigation and really cooperate with the regulators that are dealing with this particular breach. And then you have the third category of an organization like startup, SMEs, or even sectors that do not have that particular very, very strong budget. For example, in the UK and generally in the EU, education sector, schools, charities, startup, SMEs that are about to actually expand the business, they are very prone towards the data breaches. ICO in the UK particularly has actually conducted a variety of training and as well as support to help these organizations just to ensure that they really stress test their information security policy, their privacy policy, and ensure that whenever there is a breach, okay, they need to really conduct a severity assessment, whether or not it's high risk, okay, whether the breach is notifiable in the context of the UK Data Protection Act 2018, or for the Continental Europe GDPR generally, then you have to really ensure that you need to undergo this respected SOP, or standard operating procedures on the incident breach. I think in short, Nick, and as well as Ayman, in the context of UK, Europe generally, even in the US, before GDPR, most of the, I would say 20 most states in the US already have security breach notification laws before GDPR, okay, and the maturity in the US is much more mature when it comes to security breaches, but of course, it depends on how exactly you have to socialize and stress test your incident response plan, and how exactly you need to work very closely with the DPO, with the lawyers, and then with the HR and with the marketing team, even with the CEO, in terms of disseminating, okay, why the breach happened, how it happened, when it happened, and what you are doing in terms of mitigating the breach. So it involves many stakeholders. It's not just the DPO. So it's actually a teamwork.
Sure. I think for the Egyptian law, there's a few things that stand out in terms of breach notification obligations. I mean, the law itself spells out what the requirements are in terms of substance. However, two things that really stand out. One is there is nothing in the law in terms of materiality. So, in other jurisdictions, it's not uncommon to see some level of materiality in terms of what would trigger the obligation to report the breach incident. So in the Egyptian law, there's no materiality trigger. And then additionally, and I mentioned earlier, the right of the data subject to be notified of a breach. So again, it reads like an absolute right. There is no materiality dimension to that as well. So essentially, based on the law, and unless it's going to be refined in the context of the regulations, which I don't think is the case, there is an obligation to report any breach within 72 hours, and the data subject also needs to be notified. So at a practical level, I think that that's going to have quite significant implications as well. Okay, look, I think we can move on from the breach notification aspect onto that great topic of data transfers. Basically, so Ayman and I, we spoke about this the other day. In terms of the drafting of the law, personally, this data transfer dimension raises the most concerns for me. I'm used to, and again, I'll use DIFC as the example, but DIFC, it takes a very international approach, very similar to GDPR, and that is where, there is this idea of transfers to jurisdictions that are deemed to provide an adequate level of protection. Those types of transfers are basically the transfer is legitimate if it's to a country that's recognized. However, transfers to recipients in countries that aren't deemed to provide an adequate level of protection need to fall within one of a handful of derogations or justifications that can be relied on for the transfer to recipients in such other countries to be okay. Now, the Egyptian law, as it's drafted, it's not as neat as that by any stretch of the imagination. First of all, it basically says that transfers to countries that, and Ayman and I talked about this particular point, but the way that I would sort of paraphrase it is that it says that transfers to recipients well, it's prohibited to transfer personal data from Egypt to recipients, let's say in jurisdictions that don't offer a level of protection substantially the same or better than the level available in Egypt. So it's prohibited to transfer to recipient in a country other than, somewhere that has a suitable level of protection, but you still need a permit from the DPA. So the fact that you would still need a permit, even if you're transferring it to a recipient in, where suitable standards are being met, I think that need for the permit is a little bit atypical. So I think that that's something to note. And then the other thing that I thought was interesting, or confusing rather than interesting, was that there are a number of derogations that are specified in the law where you can transfer personal data to recipients in other jurisdictions in certain circumstances, but one of those, one prerequisite for that is the consent of the data subject or a representative of the data subject. So if you're transferring it anywhere else, as well as obtaining the consent of the data subject, you also need to fall within one of certain other requirements. And those requirements relate to things like vital interests of the data subject, exercise of legal rights, performance of a contract in the interests of the data subject. And then there's a handful that relate to treaty obligations, public interest, etc., and randomly cash transfers. So generally speaking, I think that whole data transfer section of the law is, it's pretty unclear, and it's almost like, they haven't properly digested the approach that's sort of taken internationally when they have drafted that sort of section. Sorry, I've said a lot on that topic, Iman, but do you have anything to add on that or to clarify?
Well, just that you mentioned that normally you would find a white list of countries where you can transfer data safely, and it's permitted by law or by the DPA. But with Egypt, with the interpretation or the reading of Article 14, I don't see that it will be expected to have a white list or a blacklist, because the article says there has to be the standard of protection. So you could have this standard of protection with one recipient in the US and not with the others. So it really doesn't depend on the country where you're transferring data. So this is the main difference that I thought to highlight between the GDPR and the Egyptian law.
And also we spoke about the fact that the law does contemplate the executive regulations providing guidelines and other information relating to this data transfer dimension. And I mean, whether or not that will be a whitelist of approved countries is a different point. And I understand from you that that's not your reading of it, but it could be that the DPA comes up with things like Egypt-specific standard contractual clauses or model clauses, that type of thing. So they've alluded to the fact that there's going to be more information on this particular point.
Yes, and maybe the DPA will, or the executive regulations will come up with certain criteria. If they are applied in certain countries, the countries will be whitelisted. Maybe there will be an evolution of things in this respect, but yeah, I do not read it from the text of the article as drafted.
Understood. Okay, look, if we move on, the next heading that we have is the regulator. I think So we've mentioned this, the DPA. It's actually in the law, it's referred to as the centre, but we've been calling it the DPA, or the Data Protection Authority. Iman, can you tell us a little bit about that? I don't think we need to go into too much detail, but just broadly speaking, what can you tell us?
Well, the DPA will have a lot of authorities and a lot of a big scope under it, because it will issue the licenses, the permits. It will ratify the entities and the individuals that will give consultancies. It will receive complaints and grievances. So it has a big role. And with respect to the constitution of the authority, or the DPA, it's as usual, there are national security concerns. So we have the board constituted of representatives from the Ministry of Defense, Ministry of Interior, the intelligence, the administrative control or authority, the NTRA, which is the National Telecom Regulator, and experts as well. So we are all looking to see how and when the authority is established, and the constitution. It will have a very big role expected. Like we see the Egyptian Competition Authority, it has become more interactive and dynamic in regulating competition issues. But this entity will start big, I'm sure.
Okay. Look, that's great. I'm conscious of time. We've actually hit the 45-minute mark, which is surprising. The last section that we wanted to cover in terms of the substantive law side of things, and I don't think we need to go into a great deal of detail on it, but basically there's a lot of significant penalties. Iman mentioned earlier things like failure to appoint a data protection officer, and also failure to perform duties as a data protection officer. Both have significant fines. The latter also has a imprisonment of not less than 6 months. There's a whole raft of things there, and things like failure to comply with data transfer requirements when transferring data abroad is an offence. Failure to comply with digital marketing requirements. So there are specific provisions in the law that talk about digital marketing. So again, if you're doing digital marketing and it's not compliant with the law, you could you could be looking at imprisonment for not less than 3 months and a fine of up to $65,000 US. Generally, failure to comply with, like, processing personal data other than in accordance with the law. Again, a fine of not less than 3 months and up to $65,000. So a failure to notify and report as specified in the law also has penalties of imprisonment and fines, etc. So you get the gist. There was a law update article that we produced a few weeks ago that does list a lot of these penalties. So if you go to Altamimi's website and look around there, you'll find a law update article on the new Egyptian data protection law. And it'll provide you with further information on that. If you need a copy of the law in English, happy for you to reach out and we can send you one. Yeah, very happy to do that. Just email us directly and we can sort that out. Perhaps just before we talk about the operational, further operational aspects, Norris, I see that there's some questions. One is about healthcare data. So healthcare data is one of the categories of data in the sensitive personal data category. So healthcare data would be captured in some ways as sensitive personal data, but in terms of healthcare data more generally, There will also be things like confidentiality obligations, broader confidentiality obligations, or healthcare sector-specific confidentiality obligations. Although I'm not sure if there are healthcare sector-specific data protection regulations in Egypt. Iman, do you know, does the Ministry of Health have any, and I'm not talking about confidentiality here, I'm talking about data processing type stuff. Is there any patient health information related rules that you're aware of?
I believe this law will cover this, because other than the general confidentiality issues, nothing is regulated to this extent as it is under this law.
Sure. Okay. Look, so in terms of the general legal provisions and what we were hoping to talk about in the law, that's it. If you do have more questions, send them in. However, on the operational side, we did think it would be quite useful to get Norris to, perhaps provide a bit more insight in terms of how businesses might try and operationalize the requirements of the Egyptian law once there's a bit more meat on the bones in terms of what the regulations require. And also bearing in mind that there's going to be different types of entities. There will be global entities that are very familiar with data protection compliance, and there'll be regional or local entities that haven't encountered this type of thing before. So Norris, can you perhaps touch on some of the key points that you think will be relevant?
Sure, Nick, thanks very much for that question. So based on the global data privacy and cybersecurity framework, what we've seen in the market is most of the matured organizations, which are multinational, they have used GDPR as the global baseline framework in their global data privacy / cyber framework. The reason is because they would like to put a much more very high standard. And in the event that if there's a new law in a particular jurisdiction or particular market or country will pass the law, they will do the regional or perhaps local variation. So how they do it is they will actually require the local council, like Mimi, and also the resource in the local jurisdictions to start to do the self-assessment vis-a-vis the differences between GDPR, which is quite common. We've seen this a lot in financial services, in TMT sector, even in life sciences, because these sectors are predominantly processing, personal data and sensitive personal data every single second. And then the second is we've seen organizations where they are actually globally headquartered in their local jurisdiction. So in this context, we take example Egypt. Let's say global, Egypt organization headquartered in Egypt, and then they also have branches in the US, in the EU, and in Asia. And they have actually taken a much more, a hybrid approach, meaning that in addition to the sector-specific laws in Egypt, they need to assess, the impact of this current new law, and as well as the other jurisdictions around the world that they are dealing with, different kind of data set in the context of the infrastructure. For example, in the cloud or even in their mobile app environment, agile environment. So this is quite local / hybrid in terms of the governance, but it's not easy. The reason why I'm saying it's not easy is because there's level of complexities, level of gray areas, even when you engage with regulators, they do not have the concrete answer, black and white answer how to deal with this. So most of these organizations, they actually have taken a much more risk-based approach. What I meant by risk-based approach is they have actually adopted the controls framework like ISO 2701. There's a new framework which is called ISO 27701, which actually have embedded privacy management and cyber control within one control environment. Because in a way, it's very good. Of course, there is law, there is compliance, but in order for the organization to demonstrate their so-called privacy management and cyber control, so this control will help them to articulate and to defend, to the regulators in the event that there's a breach. And then we have a third category of organization where they are startups and then they are SMEs. They do not have much budget and they do not have much investment in relation to not only complying with the necessary assessment of the local laws, for example, the new Egypt law, So they might struggle because they do not know how to start, how they need to deal with this. Because on the one hand, there's already existing, sector-specific laws, which even some of these provisions are stricter as compared to the, the main omnibus data protection law. We've seen this a lot in Asia, partly in China, partly in Singapore, and partly in Southeast Asia, and partly in certain jurisdictions where sector specifics are, some of the provisions are slightly, really restricted as compared to the main omnibus data protection law. So how they deal with this is they actually have really outsourced certain DPO function, or even the CISO function, to law firms, to consultants, to help them to start to do the necessary assessment. So that's actually a much more the bigger picture when it comes to assessing how exactly the global GDPR framework would actually be able to really, put the so-called, headway for the local jurisdiction. Another aspect which is very important, Ayman and Nick, is that we have seen the emergence of data inventory, information asset register, as a global, best practice. Even though there are some data protection laws in the world do not require data inventory and data mapping, it is very, very helpful. The reason is twofold. The first is if there is a data breach, the first document which the DPO needs to look at is, right, I need to know my data flow, where this data goes from Egypt to the US, from Egypt to the UK, from Egypt to the rest of the world. So ensure that is actually updated in terms of the data flow. And then they need to cross-refer that data mapping as part of the compliance defensible document to the regulators. Doesn't matter, not just in Egypt, but also other regulators around the world that might actually pursue joint investigation in the event that there is a breach, and cross-refer this to the PIA, Privacy Impact Assessment, as part of the activities whilst responding to the breach. So I anticipate that in Egypt, there will be also emergence of data inventory activities, in the context of the Egypt landscape. And then the third point, which is the last point in terms of the practicalities, Nick and Ayman, is that we have also seen that cybersecurity and data privacy is actually getting closer and closer, because the convergence is very, very important. Previously, it's either you have a DPO that sits within the general counsel team, compliance team, and then you have the CISO, CIO, which sits with the cyber, the information security team. The reason is because of data governance. The reason is because of cloud convergence, robotic process automation, new technologies that really need both, to be together rather than having a separate, kind of assessment. And it's very important because we've seen organization has started to share the budget, where general counsel, CIO, CISO, even chief data officer, data governance officer share the budget in the same pot. All right, let us actually have X budget, and then let us come up with a global holistic strategy, legal, compliance, cybersecurity, data governance, and as well as other AI, for example, if they do have a team that really want to invest in AI and work together rather than reinventing the wheel, because it's so complex. Because it's either there's issues, or there's always legal issues, there's always gray legal issues that require risk-based approach, and this is where I think it's very important to have all of the stakeholders together and watch this space. And this holistic cooperation will actually mature in the next 3 to 5 months or 3 to 5 years.
Okay. Look, just thank you for that, Norris. I see we are coming up to the top of the hour. Unfortunately, I've also seen that the platform has fed me a raft of questions that I hadn't expanded the box, and I've just seen them now. Very quickly, someone asked about record keeping. I mentioned record keeping in the that I was going to talk about it, and then I never did. But there is a particular reference in terms of the Article 4 and Article 5 of the law, which talk about the obligations on the data controller and the obligations on the data processor. And 4.9 and 5.9 both talk about record keeping obligations. They don't go into a great deal of detail, but they impose an obligation to maintain a special record of the data processing activities. Now, I've not seen anything that makes clear in the law that there's a requirement to sort of report that to the DPA, although it's not entirely clear. So on the one hand, you do have to keep a record. On the other hand, I haven't seen anything specific that says you must also notify of that record keeping activity, but I suspect that more will become apparent once the regulations issue. And I wouldn't be surprised if there is some sort of general permit type obligation that would involve also reporting on the record keeping activities, or the records of data processing activities. And then somebody else has sent a query about collection companies supporting banks that have access to banks' sensitive personal data. Will they be subject to the law? I would say that provided they are subject to the central bank's personal data processing requirements, then collection so provided they're subject to the regulation of the central bank, collection companies would not be subject to the general data protection law. But if the collection companies aren't actually subject to the regulatory control of the central bank, then I think this law will apply to them. Somebody else has said that they have no audio, so I apologize for that. Hopefully that's been resolved. All right, look, we have hit the top of the hour. We've gone slightly over. Thank you very, very much for joining. As I said, if you would like to drop us a line, we can send you a copy of an English translation of the law that we've prepared, and otherwise very happy to answer any questions that may arise after the call. Okay, so thank you very much.
Thank you.
Thank you. Have a good day.
Thanks, Norris. Thanks, Simon.